I think that what my observation, Larry, about the question you asked about the judges deciding what the facts are, or deciding what they aren't, is more of a problem at the appellate level than at the trial level, generally speaking. My experience is that trial judges, by and large, have been better, have been closer to the situation, been more open to being persuaded to what the facts are, should be. Certainly we do have some judges saying, well, I'm just not going to hear that expert. I think, by the way, we've moved in the wrong direction on experts. I'm a believer in the adversary process. If your expert is touting junk science, and then it's your opponent's job to bring that out. But at the appellate level, and we certainly have this in the Seventh Circuit, you have judges, Siddell mentioned, who, and I think you stated it exactly right, their whole training has been to have an ideological or a theoretical point of view. Sometimes it's not a right or a left ideology, it's just a theory, just their own theory. Right. And a case gets tried, a record is made, there's testimony there, the jury says, I believe X and I don't believe Y. Right. That's golden in our system. Those are the facts. And the appellate judge writes an opinion, and of course, unfortunately, you don't know how bad it is unless you were the trial lawyer, and you read the opinion and say, that wasn't the case I tried. The person just said, I'm going to reach this outcome to foment this theory, and in Chicago, of course, it's the economics and law theory, which has some good points. But, and then they said, these are the facts. Or these are what, I read an opinion by Judge Poster recently in a securities fraud case, and he actually said in his opinion that he was upholding a summary judgment, and he said, I'm going to uphold this because the facts may be such and such, and therefore I'm not going to let this case go to trial because I believe it may be this.
Let me ask this. I wanted to get back to that, because that's that whole legal technique of saying what the facts may be is well, I think we should just get rid of it. It's of course silly, but
well, we already are rid of it in theory. That violates all the rules of judging and lawyering that we know about. But when the judge has the final say, that's...
Let me say for the benefit of the audience, Marty, that when you said he upheld a summary judgment, what that in effect means for the audience is that he upheld a lower court ruling saying, I won't even let this go to the jury because I'm going to say what the facts are or are not. Right. Jan, Marty made a comment which I'm not that experienced at the trial level. In my limited experience, I have run across a situation where the trial judge, contrary to what may normally be the case, as Marty said, just didn't care what the facts were. Have you had such an experience?
Well, I think I definitely have had such an experience.
I thought you might say that.
Yes, right. Definitely written about in Jonathan Har's book, A Civil Action, which, I'm proud to say, pleased to say, is in many law schools in the country as a point of discussion. It goes back to my point about how
Can I tell you something about that?
Yes.
I could only read it 20 pages at a time. It is so painful that I couldn't read more than 20 pages at a time. But go ahead.
No, I think that he really got into the belly of the beast. He really talked about what it means to do lawyering in our system, all of it, the good, the bad, and the ugly. And so I think that it is this need for this open and honest discussion, because yes, there is this arrogance of power, and it's a terrible feeling to be a lawyer, to go into court and to have done your job, to marshal together the facts, to have the research and to say, look, here's how the facts fit with the legal theory. We don't all have to have pride of ownership. We can be wrong, but the point is to have done your job and then to have the judge come and say, well, it's not important. In other words, it doesn't really make any difference that you did your job. And so therefore you say to yourself, well, who am I? If I'm not a lawyer, am I an influence peddler? I mean, what is left to me? What is my function here for my client?
This excerpt is brought to you by the Massachusetts School of Law, the leader of reform in legal education and a leader in multimedia education for the public. To view the full interview and for a full listing of MSL's programs, log on to mslaw.edu.